Hey everyone, you've got Nisha here from Daily Cloud, and I'm here to give you your This Week in Congress update. We've got a lot to cover, so let's get started. First, I have H.R. 2820 and 2821, the DREAM Act of 2019 and the American Promise Act of 2019, respectively. Now, if those two titles sound familiar to you, you may be recalling H.R. 6, which is the American Dream and Promise Act of 2019. Well, H.R. 6 was actually split into these two bills, so let's not get the numbers confused. These are the two new bills that we're working with. So the point of those two bills is to create a path towards legal permanent residence. 2820 deals with dreamers, some of whom have DACA but should not be confused with reopening DACA. Again, it's a path towards legal permanent residence. And the 2821, the American Promise Act, deals with those with temporary permanent status, or TPS. So some things from H.R. 6 have been preserved in these two bills, and some things have changed. So let's go over some of those consistent bits and some of the changed bits. First, some of the things that remain the same is to qualify. You have to have been in the United States for 4 years of continuous presence. You have to have arrived in the U.S. before you were 18. There's also an educational component where you have to have had a higher education degree or a technical education degree or a high school diploma or a GED. So if you've got any one of those four things, you should cover that criteria. You have to have no felonies, and you can have a maximum of 2 misdemeanors. And those crimes cannot involve domestic violence unless you have that conviction because you were a victim and there was a self-defense. But that's a separate thing, so just keep in mind maximum 2 misdemeanors. And here is the new element about 2820. There is a new waiver element with respect to misdemeanors. So again, you can have 2 misdemeanors, but if you had a third misdemeanor and no convictions in the past 5 years, you can actually apply to have that third misdemeanor waived, which brings you back down to the 2, which would allow you to still qualify. Similarly, if you have 4 misdemeanors and no convictions in the last 10 years, you can actually apply to have the third and fourth misdemeanors waived, which would bring you back down to the 2 misdemeanors, which would allow you to qualify for the act. So in that sense, the new version is slightly more forgiving. So what do you get if you qualify? Well, you get a conditional permanent residency, and that can last for 10 years. But you can have the ability to have the condition removed anytime before the 10 years has elapsed, so long as you satisfy the following 3 requirements. You have to have 2 years towards a college degree, or 2 years in the military, or 3 years of employment, which you're employed at least 75% of time. The second requirement is you can't have abandoned your permanent residency. Generally, that means you can't leave for more than 6 months. Third, you have to have passed a naturalization test, which is a basic language and knowledge of fundamental history test, which is not historically an obstacle. So, if you've satisfied these 3 requirements, you get a green card. And from green card status, you can apply for citizenship. And that's sort of the framework of how H.R. 2820, which deals with dreamers, operates and carves the path towards citizenship, which is the purpose of these bills. Similarly, let's address 2821, which is those who have the TPS status, the temporary permanent status. The TPS program offers renewable protections from deportation for those who have been living in the United States and who are from a list of specified countries where the U.S. government has determined it is not safe to return to, typically because of war or natural disaster. These are currently over 300,000 people from 10 countries who are legally in the U.S. under this TPS status. People from El Salvador, Honduras, Haiti, Nepal, Nicaragua, Somalia, Sudan, South Sudan, Syria, and Yemen. And this bill is designed to, again, help create a path towards citizenship in a similar mechanism as 2820 for these people. Some other changes I want to point out in this bill as opposed to some other previous DREAM Act and American Promise Act versions is that the old versions did not have a grant program to assist eligible applicants, whereas this one does. Similarly, the kinds of offenses that categorized as felony or misdemeanors, such as traffic offenses, minor traffic offenses, historically that used to qualify as one of the strikes against your misdemeanors. It no longer does in many circumstances. Another change is that the old version of the DREAM Act only directed that expunged convictions would be treated on a case-by-case basis, and the old version of the American Promise Act remained silent on the treatment of expunged convictions. These acts do elaborate more. Importantly, the old versions of the American Promise Act did not include confidentiality provisions, but this one does. And similarly, the old version of the American Promise Act did not exempt failure to attend removal hearings, misrepresentation, previous removal, or unlawful presence, whereas this one, in certain circumstances, does exempt that. Lastly, and the last change I want to point out to you all, is that the old versions of the American Promise Act provided an opportunity for the spouse, parent, or unmarried son or daughter of the person adjusting their status under that act to also adjust their own status, and this current version does not offer that same opportunity. So that's another important change to keep in mind. So switching gears for a minute, we're going to move on to H-Res 411, which deals with the Declare War Clause and the War Powers Resolution. And what this resolution does is it elaborates on some key terms, really nailing down their definitions so that it's more apparent when the Declare Wars Clause has been violated and when the War Powers Resolution can be invoked. So to give a little bit of context of why this is important, let's talk a little bit about what the Declare War Clause is. So it's Congress's power to declare war, not the president's. The power provides that the U.S. can send armed forces into action abroad only by declaration of war by Congress, by statutory authorization, or in the case of a national emergency created by an attack on the U.S., its territories or possessions, or its armed forces. So violations of this Declare War Clause is actually considered a high crime and misdemeanor, and the penalty for such a violation is impeachment. So this is a pretty severe crime. Now, the War Powers Resolution was passed under the Nixon administration, and that holds that the president has to notify Congress within 48 hours of committing armed forces to military action, and it forbids armed forces from remaining for more than 60 days with a further 30-day withdrawal period. So the problem is, and has historically been, I'll name a few examples in a minute, that because what constituted a declaration of war or what constituted committing armed forces to military action wasn't so clearly defined, it was hard to nail down whether the War Powers Resolution could be invoked or whether the Declare War Clause had been violated in some way. So what this bill, again, aims to do is help clarify some of those definitions so that a violation is more clear. So here's some examples of when that's become a problem, and it might surprise you. There's quite a few times where this has been a problem. So Kosovo. It was alleged under the War Powers Resolution that it had been violated. President Bill Clinton in '99, during the bombing campaign in Kosovo, Congress had disapproved of all of those incidents, but none of that disapproval actually resulted in any legal action being taken against the president for alleged violations because they couldn't legally nail down whether the clause had actually been violated or whether the resolution had been violated. Similarly, in Libya, in March 2011, the Secretary of State at the time, Hillary Clinton, testified to Congress that the administration didn't need congressional authorization for its military intervention in Libya or for any further decisions about it, despite congressional objections from members on both parties that the administration was violating the War Powers Resolution, again, because they couldn't legally nail down whether the War Powers Resolution had actually been violated or not. Another example, was Syria. In late 2012 or early 2013, at the direction of President Barack Obama, the CIA was put in charge of Timber Sycamore, which was a covert program to arm and train the rebels who were fighting against Syrian President Bashar Assad, while the State Department supplied the Free Syrian Army with non-lethal aid. Following the use of chemical weapons in the Syrian civil war, Obama asked Congress for authorization to use military force in Syria, which Congress rejected. Instead, Congress actually passed a bill that specified that the Defense Secretary was authorized to provide assistance, including training, equipment, supplies, etc., but it specifically said that the U.S. was prohibited from introducing troops or other forces into the hostilities. In spite of that prohibition, Obama and later on President Trump introduced ground forces into Syria, directly contradicting what Congress's will was, and the U.S. became fully engaged in the country. You might recall on April 6th of 2017, the U.S. launched Tomahawk missiles at a Syrian airbase in response to the alleged use of chemical weapons. And a constitutional scholar, Stephen Vladeck, said that that strike, that military action, potentially violated the War Powers Resolution because Congress didn't approve it. So we see here the importance, again, of nailing down what actually constitutes this military action and military intervention when it's against the will of Congress. Most recently, in 2018, Senators Bernie Sanders, Chris Murphy, and Mike Lee, all across the political spectrum, right, sponsored a bill to invoke the War Powers Resolution to end U.S. support for the Saudi-led military intervention in Yemen. And that bill was officially introduced in January of 2019 and was approved by the Senate, but then vetoed by President Trump. What happens when the president vetoes a bill like that is that Congress then needs to get a 2/3 vote to override the presidential veto in order to then, in this case, invoke the War Powers Resolution and say that it had been violated. But the Senate was unable to get that 2/3 majority, which effectively killed the bill. So we see from these examples that it's really important in order to establish whether the Declare War Clause has been violated or the War Powers Resolution has been violated, it's really important to nail down what precisely constitutes the kind of violating military action. So back to HRES 411, something this bill describes that it's concerned about is that the absence of definitions of war and co-belligerency for purposes of the Declare War Clause undermines its enforcement through the impeachment process or otherwise. That's the heart of the concern of this resolution. So it goes on to then define what those things are. It defines war, it defines co-belligerency. So I'll explain, I think it's best to hear straight from them what co-belligerency in this case means, or how they've defined it. Is they say the U.S. becomes a co-belligerent if it systematically or substantially supplies war materials, military troops, trainers, or advisors, military intelligence, financial support, or their equivalent in association, cooperation, assistance, or common cause with another belligerent. So now that HRES 411 has nailed down these definitions a little bit more clearly, we can start to think about how some of these past examples may have turned out differently given these definitions. And further, we can think about how future actions may now be limited or maybe taken a little bit more cautiously given the more concrete definitions that we have. So that's sort of the effect and power of HRES 411. So lastly, I'm going to leave you with HRES 410, which is titled Encouraging Reunions of Divided Korean American Families. The resolution starts out with some heartbreaking facts where the division of the Korean Peninsula into North and South Korea separated more than 10 million Korean family members, and some of those family members are now U.S. citizens. In fact, it was estimated in 2001 that 100,000 of those separated, divided family members were in the United States, But since 2001, that number has dwindled as many of these people have gotten older and passed away. So, in 2018, North Korea and South Korea actually had a summit that prioritized family reunions. Similarly, the US and North Korea have engaged in talks during two summits, one in 2019 in Singapore, one in June 2018 in Singapore, and one in February 2019 in Hanoi. And there, they prioritized bringing these families back together. There are so many Korean American families that have been waiting for the chance to meet their relatives in North Korea for the first time in 60 years. So, what this resolution calls for is for the United States and Korea to begin the process of reunited Korean American divided families with their immediate relatives within 60 days of the adoption of this very resolution, which was introduced this last week. They plan to do that by exchanging information to divided family members in the U.S. and North Korea who are willing and able to participate in this pilot program for reuniting families, and find matches for members of the divided family members through registries, through organizations like the Red Cross, and working with the South Korean government to include American citizens in inter-Korean video reunions. What a good way to use technology. It also calls upon the U.S. and North Korea to, and I quote, pursue reunions as a humanitarian priority of immediate concern, delinked as much as possible from conflict. So it's uplifting to hear that the U.S. and North Korea are able to put aside some of their differences and agree that these families are a priority over all of the political turmoil, over all of the other conflicts. Is bringing these families back together is the immediate concern, the humanitarian concern. So I'll leave you with that good, hopeful news, and thank you so much for watching. We covered today the DREAM Act and the American Promise Act. We covered HRES 411 about the Declare War Clause, and we covered the Reuniting of Korean American Families Resolution 2. So if you enjoyed this video, please like, subscribe to our channel, check out our page, leave some comments. We love to hear from you all. And thank you so much for watching. I hope you all have a wonderful rest of your week, and I'll talk to you all again soon. Bye now.